Hello, everyone. My name is Teresa McClenahan, Executive Director and Counsel at the Canadian Environmental Law Association. Thank you for joining us for this episode of Walkerton's Drinking Water Protection Legacy. In this series, we commemorate the 20th anniversary of the contamination of Walkerton's water supply by speaking with the people who experienced the tragedy and the inquiry that followed firsthand. With me today is Joseph Castrilli. Joe is currently a lawyer at the Canadian Environmental Law Association, representing clients across the province of Ontario. Joe was one of CELA's first employees in the 1970s before he went to law school, after which he practiced environmental law in private practice for 22 years. During that time, Joe was counsel to the Ontario Waterworks Association and the Ontario Municipal Water Association for Part 2 of the Walkerton Inquiry. Joe holds a law degree from Queen's, an LLM from Lewis and Clark, and is a member of the British Columbia and Ontario bars, as well as a Law Society of Ontario Certified Specialist in Environmental Law. Welcome, Joe.
Hi, Teresa. Thank you.
So the Walkerton Inquiry was conducted in two parts. Part one was about the questions of causation to the tragedy. Why was it important for you to represent the Ontario Waterworks Association and the Ontario Municipal Water Association during part two of the inquiry?
Well, Teresa, as you know, the Ontario Waterworks Association, which is a section of the American Waterworks Association, and the Ontario Municipal Water Association as combined groups represent the drinking water profession in Ontario and did so 20 years ago. And their members include the engineering professionals as well as the municipal governments that are responsible for protecting public health in the treatment and delivery of safe drinking water in the province. At the time of the Walkerton tragedy, both organizations were deeply concerned about the impact that the events at Walkerton had on really province-wide public confidence in the drinking water system, to which many of their members had really dedicated their entire professional careers to. Right. So they saw part two of the inquiry, which, as you know, was about how to develop a new strategy relating to the provision of safe drinking water in the province, as an opportunity to ensure meaningful public understanding, perhaps for the first time, of what the existing system was like, how it might be reformed, and also in that process, restoring public confidence to that system going forward. The leadership group that I worked with at both organizations was extremely knowledgeable as well as keen to participate in part two, knowing that it was going to engage in a thoroughgoing examination of the existing system, particularly with respect to applicable laws and policies, but also their reform. So I think in short, it was an important case. I had a dedicated client group and the stakes were high.
Right. So thinking back now, what do you think were some of the significant outcomes from part two of the Walkerton Inquiry?
There are two that stick out in my mind. The first relates to public education about the drinking water system in Ontario, and secondly, how to reform it. In terms of public education, as you know, the Part 2 report produced by Justice O'Connor set out in fairly easy language the components of the drinking water system and why they were important. So it allowed the ordinary members of the public to develop an understanding of why the drinking water system was important to them. And it allowed them to consider many of the things that were effectively dealt with in both parts of the inquiry, but in particular in part two, protection of drinking water sources as part of a watershed planning basis.
Right.
Standards and technology for treating and monitoring water quality. Developing an accreditation program for municipal water providers, and accompanying that mandatory training and certification. It also allowed us to ensure that we had a robust, what I would call a robust provincial oversight of the system, and also allowed us to develop special attention to small water systems, which, as you know, the Walkerton system would have fallen into that category, and also to address issues surrounding water supplies for First Nations. So all of those items really were in the nature of helping the public to understand the drinking water regime we had in the province. Out of those items, which were many of the measures and issues that were examined by Justice O'Connor in Part 2, came the law reform part. And I think two of the most important that came out of the over 100 recommendations from Justice O'Connor was the development and enactment of a safe drinking water law in 2002. And also in terms of addressing the issue of developing a first barrier in the system, the development and enactment of the Clean Water Act in 2006. And of course, as you know, there were also a variety of standards and regulations, plans, policies, and institutions that came with those two laws, which really were developed in the many years following the inquiry. And I would think really until almost the 2010s, we were still developing measures arising out of the inquiry itself.
Right, right. So thinking back to being a lawyer at the inquiry, what are some of your significant recollections of that inquiry and what it was like to participate?
Well, unlike part one of the inquiry, which, as you mentioned in your opening comments, which was more in the nature of a public inquiry into what took place at Walkerton and what were the causes, part two was more in the nature of a law reform commission review into what the province-wide drinking water system was like in 2000 and what it should look like going forward. So, and part two itself was really divided into two parts. The initial part was a series of meetings that were led by experts in areas like engineering, science, and finance, which really related to different components of the drinking water system itself. And the latter sessions of part two were the more formal proceedings before Justice O'Connor himself, where he received submissions from parties appearing before him in part two. And he basically led the questioning of those making submissions either directly himself or through commission counsel. It was my job as part of representing OWWA and OMWA to help them put together their case, so to speak, in the sessions that Justice O'Connor appeared before. And in particular, what we ended up doing over about a 13 or 14 month period was we produced over 10 major reports and over 100 recommendations that were used by Justice O'Connor, I think predominantly, I would think, only in relation to part two. In the year after in which he finished his inquiry. So that was sort of the nuts and bolts of what we did in part two. But I think what was gratifying for the clients and what I think I remember most were some of the sessions that Justice O'Connor attended subsequent to the end of the inquiry, where he appeared before the annual general meeting for both organizations, and he went out of his way to pay both organizations compliments for the information and the professionalism they brought to bear on the tasks that he was investigating during the course of the inquiry itself.
And for my part, wearing various hats in the subsequent years, I definitely worked closely with many of the members of those leadership teams as various pieces were implemented. And a funny anecdote, Joe, you had another role before your retainer for the inquiry where you had been asked by CELA to do a model water bill. That's and right. That model water bill we ended up converting into a submission to the inquiry. And so when I was at part two, it was my job to advance that model water bill. And I was on the receiving end of Justice O'Connor's questions about why we needed to go beyond the existing conservation authority system in implementing a watershed approach. So that's another interesting.
I didn't know that actually.
Yeah,
I remembered I had done the draft for you folks,
yeah,
and
yeah.
that it was around the time, but I guess it was actually before the inquiry.
Hmm.
But I didn't
Hmm.
realize you ended up getting grilled on it.
I did. I was defending your work. So thinking about it now, 20 years later, what do you hope we as a society remember about the Walkerton experience going forward?
Well, as you know, I think Walkerton began as an environmental problem that pretty quickly morphed into a public health tragedy. I think we should probably never forget that a safe environment and protection of public health go hand in hand. That was true 20 years ago, and it's certainly true today.
Hmm. Hmm. Well, again, the leadership of the Ontario Waterworks Association and the Municipal Waters Association were participating in some of the advisory committees to successive governments after the Walkerton Inquiry that I also sat on. And they joined with me in strongly recommending to the province that we needed health representation on some of those committees, which originally hadn't been established. And that advice was taken up, I think, largely because of the opinion being expressed by the by the water treatment industry, that the health perspective was very much needed as we looked at the necessary reforms and how to implement them. So this interview is one of a short series titled Walkerton's Drinking Water Protection Legacy, curated by CELA, to be housed on the CELA Foundation's environmental history pages. In this series, we focus on the essential lessons learned from one of our significant CELA cases, the Walkerton Inquiry, and how to ensure drinking water protection and environmental protection is safeguarded into the future. Joseph Castrilli was counsel to the Ontario Waterworks Association and the Ontario Municipal Water Association during phase 2 of the Walkerton Inquiry. Joe, thank you so much for joining us today.
Thanks, Teresa. This has been fun. Bye now.